This is Fusion Capitalism, a clean energy vision for conservatives. Brought to you by industry leader and company CEO, Steve Malink. Here's Steve.
Welcome back to the second part of my interview with Jody Freeman, a Harvard law professor and director of the school's Environmental and Energy Law program. Jody, in part one, we got your thoughts on the election and its effect on climate change in the future. But now I want to shift over to the judicial branch and the confirmation of Amy Coney Barrett. You said this about the appointment of Amy Coney Barrett to the Supreme Court. It's going to be a corporate court, good for business, good for corporations. Let me ask the obvious question. Why?
Well, I think because the lineup on the Supreme Court right now, even before Coney Barrett's confirmation, was very much headed in the direction of being skeptical about regulatory power, and especially skeptical of agencies like, say, the Environmental Protection Agency that try to do expansive things under their statutes, but may perhaps lack explicit legal text. In other words, there's some broadly worded statutes that say things like set standards using the best system, okay? And agencies trying to then create policies out of those broad mandates are finding they run into trouble with the Supreme Court because the Supreme Court wants Congress to have been extremely explicit about what the agency is allowed to do. And we see a majority of the court very suspicious of agency regulation and prepared to strike it down and send it back to Congress for clear instructions. And that's a bit of a recipe to hang agencies up and sort of stop regulation in its tracks. And Amy Coney Barrett's philosophy of how she reads text, how she reads statutes, looks like it lines up with that and looks like she's going to be also skeptical of government power. So when I say it's going to be a corporate court, I think that's because there's going to be a certain amount of antipathy toward the federal government and its potential overreach. Many justices on the court have commented about the accretion and accumulation of power in the administrative state. So there's a bit of a warning coming, I think. Already we've seen it that I think she aligns with pretty well.
Some say she would make it harder for environmentalists to win at the Supreme Court. Should this be a concern for all those of us who want to address climate change?
Yeah, I had a piece out in Vox this week, actually, where I made a long argument, gave some analysis of how I think her vote will matter or won't matter in environmental law and to climate change. And one of the things I said was that she seems to have a restrictive view of standing. That is, she'll take kind of a harder view of what do you have to show to get access to the court to press your claim. She may have a more restrictive view of the Commerce Clause, which means narrower view of Congress's power to regulate in the first place to protect us from environmental harm. I sort of added up all the views that I thought her judicial philosophy supported, and it came out in a place where it's probably incrementally harder for environmentalists to win with an Amy Coney Barrett added to the existing conservative majority. Now you've got 6 votes that in all these respects make it a bit harder for environmentalists to first get into court. And then, what they meet is skepticism about regulation when they get there. So you think about it and it's probably not the trend you're looking for if you're trying to press environmental protection and climate change action in the courts.
So specifically, should we be worried about the 2006 EPA emissions reporting decision, which compels the federal government to regulate carbon emissions?
So just a few little law professor notes on that, because I can't help myself. It's this 2007 case, right, called Mass versus EPA.
All right, thank you.
And just to be particular, because that's what we do when we're law professors, it didn't say EPA has to regulate greenhouse gases. It just was the reason this was a landmark case was it said that EPA has the authority. So it said that greenhouse gases are pollutants under the Clean Air Act. But to answer your question, I don't think that the Supreme Court's going to overrule that case, mostly because they don't tend to overrule precedents that have interpreted statutes. If they're going to undo precedent, it may be in the constitutional law area. This isn't a constitutional law case. It has to do with the Clean Air Act, which is a statute. So I don't think it's in jeopardy because I don't think they're going to go back and overrule it, partly because they don't have to. They can cabin the Environmental Protection Agency's power by interpreting their authority narrowly. So when the EPA comes with a new rule, the court can always kind of constrain them. by reading their authority narrowly. So I think Coney Barrett, if that case were relitigated today, now if that happened, I believe that she would vote with the conservative majority, and probably it would have come out the other way.
I see.
But I don't think it will be, and I don't think they're going to bother to try to undo it as a
I see.
precedent.
During her hearing, Amy Coney Barrett said that while she has read up on the issue of climate change, she did not have any firm views. Do you think she was just being consistent with what she was saying on other topics such as abortion and healthcare? Or do you have any concerns that she doesn't have any firm views on climate change?
Well, I have to say she was the least forthcoming nominee. I think there was a study done, even already it's been done to show that she's the least forthcoming since I think Abe Fortas, the last least forthcoming nominee. I mean, she really said nothing. And so I think this is of a piece with her trying to say nothing. But it was a little alarming how she put it, right? I mean, this language of "I'm not a scientist." I mean, that's just that statement is a Republican talking point for saying nobody can speak about this unless they're a scientist, and sort of it seems to kind of validate a view that is, this is all debatable. So the framing of it kind of drew concern. I mean, I'm not a scientist, but I do know that the Earth is not flat. So there is I thought it was kind of silly, and
Sure.
why wouldn't she have just said, "Look, this is what the science says, but that doesn't tell you anything about a particular case," right? So it was a little
Okay.
troubling, but you could see it was part of her strategy to
Sure.
say nothing.
Right. Now, conservatives have long challenged how much courts should defer to agency interpretations of the National Environmental Policy Act. In your opinion, why is it so hard for them to accept the strategic benefits of clean energy?
Yeah, I mean, this
Why
is
do
a
we have
bigger,
this
yeah.
misalignment between conservatives and progressives on this great opportunity of clean energy?
Well, so those are two different questions with two different answers. The first one is about courts not wanting to defer to agencies. And I think, as I was saying before, there is this detectable trend where the conservative majority on the Supreme Court really looks askance at agency power, and they don't want to defer to it. And when the agencies are trying to do something ambitious or expansive, say to regulate greenhouse gases, the court really is not very deferential at all. And so I think we're in an era of less deference. The court is taking some power back. And if you're pro-environmental regulation, that's not a good thing, right? Because that looks like less deference to the experts means probably more skepticism about regulation. The second question, though, which is, why is there this divide over clean energy between Republicans and Democrats? I am a little mystified. I mean, I get politics, but I am a little mystified because it should be completely nonpartisan or bipartisan, There's money to be made. Clean energy innovation is profitable. It's potentially a realm of American leadership. It's an area we could dominate if we could invest in
Yeah.
it. So all those themes are Republican themes. So I'm puzzled because I think if climate change were not the frame on it, I think we could make a lot of progress across the partisan lines. We could
Sure.
find an alliance, but climate change seems to have just leapt the scientific fence and somehow has become one of these issues, right? These hyper partisan issues where if the other side's for it, you're against it, kind of thing. And it's such a shame because
Yeah.
right? It's such an opportunity. This whole domain of clean energy technology, it's such an opportunity, and it's a shame to me that it's become embroiled in this kind of hyper-partisanship.
Yeah, another word for problem is opportunity, and maybe we just need to stop talking about the problem and really focus on the opportunity, and maybe we'd get more traction.
It's tough, right? Because yes, while framing it as an opportunity seems to me correct and appealing, there is a problem. That's
Yes.
the thing. There really is.
Yes.
And I remember when I was in the Obama administration, the science advisor, his name is John Holdren, and he actually was also a colleague of mine at Harvard. We like to go into government service, we Harvard types. And John Holdren, the science advisor, he would be in meetings and people would talk about framing, like you and I are, framing that's clean energy. But John would always say, but there is a climate change problem. Like we need to talk about that.
Yeah.
So that's what I mean. I think that the motivation and the desire to do something has to come from
Sure.
somewhere, so it's hard not to talk about it.
So for my last question, we've devoted a lot of time to talking about the incoming justice. Can you tell all of us how the late Justice Ruth Bader Ginsburg led the way on environmental law?
Yes, Ruth Bader Ginsburg authored some important Supreme Court opinions. She wrote the opinion in a case called American Electric Power versus Connecticut, which was a case that reinforced that EPA has the authority to regulate greenhouse gases. This was sort of the second case after the big Massachusetts versus EPA precedent you talked about earlier. She also wrote another important air pollution decision which upheld a market scheme that EPA had adopted for trading, for budgets and trading in interstate air pollution. She wrote that case. She wrote an important case on standing, allowing environmental plaintiffs to get standing to sue, even if they couldn't show harm to the environment, but they could show harm to themselves. So in other words, she was the author of some important environmental law cases. But more importantly, she was a vote on the court that was an open vote that was, she had an open attitude toward agency arguments when they come in and say, we're dealing with these problems, we're dealing with these risks, we're deploying our law this way, our statute this way, we're interpreting our power that way. She was just a persuadable justice. And she wasn't, a shoo-in. You didn't know you got her vote, but you could argue to her that here's why we did this and here are our reasons. And we have fewer and fewer justices open to those arguments about agency regulation. So she will be really missed for that reason. She was a rigorous, really good justice. She wasn't really an environmental hero quite the way that a couple of justices have been in history. We've had a couple of famous ones, Justice Douglas and Justice Stevens more recently. He's actually the author of the decision in Mass versus EPA. But she was an important vote and an important voice. And Coney Barrett's attitude, judicial philosophy, approach to reading law is just diametrically opposed to hers.
Yeah.
So it'll be quite a shift to see.
Yeah. So do you have any other comments or thoughts that you would like to make that perhaps I didn't get from you, I guess, through my questions?
I guess the only thing I'd say is, what I'm sort of looking for in a new Biden administration, if he were to win, I'm looking for a few things. I think the administration would very quickly rejoin the Paris Agreement. And I think, and that of course is unilateral. The president can make that announcement and has to send an instrument over to do that, but doesn't need the Congress. But I also think the president will start right away rehabilitating the deregulation that the Trump administration has been prosecuting, and I'll put rules back in place, I think, as fast as he can. And then the third piece is looking for Congress. What will happen in Congress? It's going to be a very busy, very pressured time to deal with COVID and deal with the economic recovery. And the question is, where will climate change fit, in all this? And I think I'm looking to see if there is a big recovery act, a big spending bill, will we see some climate policy happen in that spending bill? And I think that's likely. And so I'm looking at all that. Where are all the levers that can be pulled to make progress on climate change in the federal government?
Okay, very good. Well, thank you for your time. This has all been very interesting. We're kindred souls in a way, though I'm more on the engineering and business side of things. I don't know much about your side, but it's very heartening to know that people like yourself are doing what you can to move us towards a cleaner energy economy.
Well, thank you. I appreciate your perspective and your podcast too. Business friendly.
Yes. Okay. All right, Jody. Thanks for your time.
Okay, my pleasure.
Thanks for listening to Fusion Capitalism. To find out more about Steve Malink and his book, go to fusioncapitalism.com. This has been a production of Forbes Books Radio.